Hi, welcome to all of our followers. My name is Stephanie Mata. I'm an associate attorney here at the law offices of Beltran, Brito, Casimir. To my right,
I am Gil Brito, the managing partner of Beltran, Brito, Casimir LLP here in Miami. Today we are talking about a hot topic, and a hot topic is visa bulletins.
right.
Visa bulletins are basically a quota system that is released by the Department of State. The Department of State controls how many visas are given each year. And by the way, when we're talking about visas, Stephanie, we're talking about green cards.
Right.
Okay? So there's this idea, there's temporary visas, work visas, and there's immigrant visas. We're talking green cards today, and we're talking about this quota system set up by law for each and various and different categories that have been established by Congress as to quotas. Quotas for family cases, quotas for employment type cases, and we're going to go into each category and we're going to talk about that quota system. We're going to talk about why is this kind of top of the news. Is because there's something called retrogression. Okay, there's a significant amount of retrogression in various categories. What does retrogression mean?
So essentially, as a general matter, there are a certain number of visas that are presented per year, right? So it is for family-based, it is 226,000, and for employment-based, 140,000. These are individuals that can apply for permanent residency. Now, if in a certain category, which is what we'll discuss below, we have gone over the limit or over the quota for that year, then we retrogress. And essentially, they're going to look at petitions that were accepted on a certain date, right?
Basically, the category is what's called over-applied.
Correct.
There's too many applicants. Okay, so there's too many applicants, and it creates a backlog, basically,
right.
And the category retrogresses. Sometimes the retrogression is a few months. Sometimes the retrogression is a decade. It really, or actually, and unfortunately, in some categories, it's getting to the point of 20 years,
yeah.
2 decades of retrogression, particularly in some family-based categories that we'll talk about individually. But so, how do we decide? So when you're looking at this visa bulletin, how do you actually decide what am I looking at here when I'm looking at the date? What is this date called?
So that is the priority date. For the majority of cases, majority of situations, the priority date is when you have submitted either your I-130 for family-based cases or your I-140 for employment-based cases to immigration. The date that your application gets to immigration.
Right, and there's an important caveat there. For employment-based cases, if it's based on a labor certification process, also called the PERM, if it's based on that, it's the day that the Department of Labor accepted the labor certification or the PERM, that becomes the priority date. So when we're looking at these tables, okay, and we're looking at all these dates, we're talking about the priority date. Usually, when you file the I-130 or the I-140 petition, you're like, well, where do I find the priority date? It's on the receipt. Okay, you look at the actual receipt, and the receipt is going to go ahead and have, one of the little boxes, basically the mail received date, the receipt date, and they'll have something called priority date. The priority date is what you're going by when we're reviewing these charts, when we're talking about retrogression.
Right. So essentially, the first one is we're going to go ahead and go category by category now, and as we discussed, the two general ones are family and employment. First, you go into family, and there's split up into essentially 4 to 5 categories, right? So F1. F1, go and tell us what it is.
Yeah, so it's going to be United States citizens petitioning any child over 21 years old. Obviously, children that are under 21 years old usually fall under the category of immediate relative. When we're talking about quota systems, when we're talking about the visa bulletin, we are not talking about immediate relative categories.
Three, right?
Which are mainly 3, which is going to be United States citizen petitioning for parent, if they are over 21, United States citizen petitioning for child that is under 21, and United States citizen petitioning for their spouse.
But these are not
they're not
subject
covered
to any
here,
sort of quota.
and they're not subject to it. So when we're talking about category F1, this is a United States citizen that is petitioning for a child over the age of 21. Okay.
Right.
Currently, that category, for you to have an idea, they are right now processing cases that were filed on or before June 1st, 2011. So when people say, well, I have, my parents petition for me, but I have to wait another 2 or 3 years. What they're talking about is this date. And it's really important that the moment that you are able to go ahead and petition for that family member, it should be done typically given the circumstances, the individual situation, but it should actually be done sooner than later. And one common theme here as we go through these numbers and we look at these actual dates, that the longer you wait, actually the worse it is.
Right. The next category, the F2, that is actually, basically legal permanent residents in the United States or green card holders also have certain benefits, right?
Yes.
So a legal permanent resident, F2A, can petition for their spouse or their children under 21. And F2B, they can also petition for their unmarried children over 21.
What happens if they're married?
There's no purpose or there's no reason for Congress to essentially want to give this.
There's no family reunification purpose. So generally, there's always this idea that immigration, the underlying theme, it's about family reunification. So if you're a green card holder and your son or daughter is married, that's a very low priority to them. Since that's a low priority, it is not even allowed. Right. You may not petition a child that's married if you only have a green card. How about if you're a United States citizen?
So if you're a green card holder and then you become a U.S. citizen, at that point you then can petition for your married child over 20, a married child, and that is for the F3.
And
right?
that's the third preference category.
Third preference category, of which there are 23,400 available, and as we said, the numbers change as you go down. This is a lower priority than the unmarried child, right?
Sure.
The F4 is the final category in this case, which is brothers and sisters of U.S. citizens, right? This is anyone, it's the lowest priority, but it is still an option. What we've discussed, Gil, is essentially this category it's been in talks that this category may be eliminated.
It might be eliminated in the future. Obviously, if you're waiting in line for it, no, it's not. It doesn't mean that it's going to be canceled for you and terminated. It means those people that are going to be applying in the future. There's been talks about it. They haven't, nothing's in stone, nothing has been decided, but there's been talks about it. They're basically saying that category does not really serve congressional intent for family reunification.
So the idea is, if you want to petition for your brother or sister now, do so as soon as possible.
You should probably want to do so sooner than later. It's really important, I think, Stephanie, to discuss what does this all mean. Right. What does it all mean when we're talking about these charts and the dates and everything? We already discussed priority dates, and we already said, okay, the priority date is actually the most important thing, because based on that priority date, we're going to go ahead and determine which category, which quota. But it's really important to note that this really means when I can obtain and when a green card is available for me. Okay? So that means either I'm living outside of the United States and I could process an immigrant visa via the U.S. consulate, or if I am legal here in the U.S. with legal status in the U.S., I'm able to file for a adjustment of status. I'm able to change my status to that of green card. So when we're talking about visa numbers, what does it mean? It means, when can I get a green card? Okay, when can I apply for this second stage of a legal process? That's what it really means. And I really emphasize the fact that in most situations, if you are doing this in the U.S., you must have typically valid non-immigrant status, okay, throughout the time that you're waiting for this visa number to become available. What happens if you fall out of status? And I get this consultation quite frequently, which is, a notario, a paralegal did a petition for me 8 years ago for a family base. I'm not legal in the U.S., but I'm just waiting for this petition to be approved. And I say, listen, there's nothing to be done.
It's a two-step process.
It's a two-step process, and you're completely out of status in the U.S. You're not going to obtain a green card based on that family petition, okay, because you've fallen out of status and you're in the United States. If you would be outside the U.S., and you wait the prescribed amount of time, you're perfectly fine. You will receive your immigrant visa. You will receive a green card in the future.
So essentially filing that first step, which is showing that you have a family category or an employment category, does not give you legal status in the United States.
It does
not.
It does not. A petition in and of itself is just a petition. It does not confer any legal status to the beneficiary.
Gil, a frequent question that I get is essentially why, when we're looking at the chart, are certain countries delineated differently?
Yeah. So, there's a maximum prescribed percentage per country, right? This is going to be prescribed by Congress, and that is going to be 7%. Okay, so what does that mean, 7?
Essentially, there are 7% of the total can be given to one country. So if one country, more applicants from that country, more than 7% come from that certain country, then they become retrogressed. They've over-applied to that category.
Sure.
So for instance, we're looking at family-based 1, which is unmarried sons and daughters of U.S. citizens. If you are from China, they're looking at petitions from June 2011. Why? Because over 7% of individuals from China applied in a given year, and so we're looking backwards. We're retrogressed in that specific category.
Sure. Category that's particularly bad. China's actually not that bad, but a category that's really bad is Mexico. So if you're a Mexican national and your United States citizen parent petition for you and you are not married, they are processing August 1st, 1997 cases.
2 decades.
That's a 2-decade wait. Something important about the visa bulletin is next month's visa bulletin. So this comes out every single month, usually a couple weeks before. Okay, the actual start of the month, and the bulletin for October is what we're talking about and discussing today, and that came out last week. For example, what happens now is just because we jump now to the November bulletin, it doesn't mean that moved the month. It might not have moved the month. It might have actually gone backwards. So there's this idea that as time goes on, this actually increments, and it's going to be on a month by month. Not necessarily. Sometimes it jumps 2 and 3 years from one month to the other. Sometimes it retrogresses 2 years, for example. Okay, so just because this has nothing to do with the actual movement of time, it really has to do with how many people have applied in the category.
And the important thing is, the reason we're talking about that now is because the fiscal year of immigration does begin in October. So in theory, in October, we're going back to zero, and we're going to go ahead and start the release of visas once again, right? That's why we're talking about it now.
Yeah. So let's go back to that point, which is, I think, essential. So the U.S. government's fiscal year is from October 1st through September 30th. Mm-hmm. So October 1st, generally, you're going to have a release of quite a bit of visa numbers, and there's this idea that a lot of the categories, not so much in the family will move a bit, but it's going to be pretty much consistent over time. What's really is going to go ahead and move, and we'll talk about that now, is the employment categories. When we're talking employment, we're talking extraordinary ability, we're talking manager executive, we're talking outstanding researcher, we're talking about advanced degree holders, labor certification process, bachelor's degree holders, labor certification process. Typically, they become current October 1st, depends on the category, and if it's going to be, on the country limitation as well. So for countries like China, India, the Philippines, Mexico, you're going to have more applicants, so that you're going to have a longer wait time in those categories. But typically, and one of our categories, and one of the main categories we do in our office here, is the extraordinary ability categories, the EB11 category. Really the first time that this category has been retrogressed to this level since 2005, I think. Okay, so since 2005, really October 1st, the beginning of the fiscal year. What does that mean? That doesn't mean that next month it might not be current. That doesn't mean there's not going to be visa numbers in December or in January. It just means today, right now, believe it or not, and this is officially from USCIS, they don't know. They don't know how many they have. They have no idea, so there's this estimate. So hence the reason there's retrogression. They think they have, they're dealing with let's talk about employment. They think they're dealing with there's 2 charts for employment. They think they're dealing with the June 1st, 2018 cases. So that means if you filed your I-140 petition June 1st, 2018, on October 1st, now in 10 days, you can go ahead and file
Stage 2.
Stage 2. Okay, because there's a visa number available for you.
Right.
Okay, now that could let's talk about the fact that there's 2 charts.
Right.
So when you look at the visa bulletin, there's something called final action date, and then there's something called
dates for filing.
Dates for filing. Okay. Generally, USCIS, and as a general rule, we go by the first chart. So if you're looking at the visa bulletin, you could just Google it, find it on the Department of State website. You look at the October visa bulletin, you're going to see that there's going to be 2 charts, and 2 charts for family, 2 charts for employment. Generally speaking, go by the first chart. However, for the first time that I've seen, I think maybe ever since they started doing this, October 2015, USCIS started doing this with the Department of State. They came out on the USCIS website and they said, you know what? We're not following chart number 1 final action dates, we're following chart number 2, which is quite beneficial. Okay, chart number 2 is quite beneficial. It's processing June 1st, 2018 versus chart number 1 you're talking about is processing April 1st, 2017. A year plus more. You're talking 14, 15 months additional wait time. Okay, so it's actually quite favorable. So when I'm trying to figure out, I need to file for my adjustment of status application, or I'm going to process my immigrant visa, and I'm in the extraordinary ability category, I'm going by the June 1st, 2018 date. That is extremely favorable for us. Okay, that is a very good thing. Interestingly enough, they actually clumped in now. When we're talking about different countries, El Salvador, Guatemala, and Honduras as well. And they are now a preference category as well, such as China, India, Mexico, and Philippines. Let's take a case like India. So with India, October 1st, 2017. If you filed your I-140 petition for the EB-11 category on or before October 1st, 2017, you can file stage 2 of the application, or they could go ahead and finalize processing your immigrant petition.
Correct.
Okay.
So let's go ahead and go into the specific categories, right, Gil? So as we discussed, for employment-based visas, they do give $140,000 a year, right? So 28% of those are given to each EB1, EB2, EB3.
Yes.
EB1 is essentially what we've been talking about, which is a lot of the cases what we do frequently, which is residency based on talent. Here is also outstanding professors. Here is also L1 executives. So there's a couple of options for this category. And that's 28% of the 148,000, which is roughly 40,000.
40,000 more or less.
Correct. Once we go to EB2, we're looking at individuals with advanced degrees. So usually individuals who are doing labor certifications that have master's degrees, this is going to be also roughly 40,000 a year. And that EB3 is going to be also usually labor certifications with lower degrees. The important part for these categories frequently is that they can take from the latter two categories, which we'll discuss now, which aren't as applied to us frequently. So if there are, for instance, there's the EB5, the famous EB5, which is for investors of roughly 500,000 or 1 million depending. Mm-hmm. If not enough people applying for that category, they didn't reach the quota, they can move those to the EB1, and there's more availability.
By law, they add those in. So as the year progresses, depending on the availability of visas, they have the ability to move them in. So we'll see right now that they're processing EB1 June 1st, 2018, very likely by December. Okay, or January of this year. There's some predictions that it's going to be current. What does it mean to be current, Stephanie?
Current is essentially you can, at this point in time, file stage 2. Either you can adjust your status while you're in the United States, or you are ready to go ahead and continue with your consular processing and get your immigrant visa.
So when you're looking at the actual visa bulletin, if there's not a date, there'll be a big C, capital C. Capital C means it's current, means it's not over-applied, means you could actually even potentially concurrently file an I-140, I-45 petition, means that there is a visa available and ready for that applicant.
Right. Gil, I was reviewing some of the questions we've received. One of the questions we've received is essentially, okay, so going back to family, an American citizen, is there a benefit for their spouse's children?
Yeah, it's a great question.
Stepdaughters.
It's all about when that marriage occurred. Okay, so the step-parent relationship is established before the age of 18. Okay, for U.S. immigration purposes. So it's not 21. So maybe the child's under 21 and you're able to petition for them, but you needed to be married with that child's mother, father, prior to that child turning 18 years old. So as long as you were married prior to that event, that event occurred prior to the child turning 18 years old, then that child, it's what's considered a stepchild, same benefits as a child, as your child as a United States citizen, and you can petition for them. If they are over 18, that child is out and you are not allowed to petition for them.
Correct. We have another question, which is essentially, when it comes to family base, can we change categories? So for instance, if you are unmarried at the time that your U.S. citizen petitions for you, can you, when you go become married, are you still part of the same category? No.
Yeah, so you're talking about mom or dad petition for me.
Correct.
And then I went ahead.
not married at the time.
Not married at the time, so that's category F1.
Right.
Okay, first preference. And then now I'm married. What happens? Automatically,
you
move down to F3. Unfortunately, you now have an extra 5 or 6 year wait.
Right.
Unfortunately, because that's an overprescribed category. You do need to notify. If the case is pending with USCIS, you need to notify USCIS. If the case is pending with the NVC, I suggest you contact the National Visa Center and let them know that you have now changed categories.
And Gil, another question that we have is really an example, which I think is good for us. So this is an individual who filed their I-130 for their brother or sister in 2006. How long is their wait?
Right now, you're roughly looking at.
We're
who is
here.
the applicant?
Brother or sister?
Yeah, you're talking February 2005. So
You applied in 2006, maybe a year, roughly?
it's going to be roughly a year. Again, I'll repeat, that doesn't mean just because we go a year in time on a calendar does not mean that this will necessarily move a year. Sometimes, unfortunately, it moves the other way and it's going to go backwards. So we just have to keep that in mind. So that's a common question, is us kind of prognosticating when is a visa going to become available. As a general rule of thumb, I think it's fine to say, hey, I filed the petition February 2006. They're processing February 2005. It's going to be roughly a year additional wait. But hold on. That means now the NVC, if you're outside the U.S., can take action.
Right.
Okay.
They could begin contacting.
They could be. So you're still not going to get a green card probably for another 6, 7, 8 months, 10 months down the road. Just something to keep in mind. If you're outside the U.S., if you're in the U.S. and you are in legal status, now I can file stage 2. Okay, and I can file stage 2, and the green card process in the U.S. is going to take roughly over 1 year, depending on the category, depending on how delayed they are at the local offices. But get ready that it could be anywhere between 18 to 24 months as well.
Right. Gil, I don't believe we have any other questions. Any final thoughts?
I mean, I think it's important to be aware of the Visa Bulletin. If there is a petition that you're waiting for on a decision, you could go on there. You could actually put your email down. They will even email you the brand new Visa Bulletin whenever it comes out. You could be on top of that. You need to know your category. You need to know the dates. It's very important. If you've had a petition that's been pending over 8 years and you haven't really looked at it in a long time, you need to look at it. Okay, you need to look at it because maybe, and this actually I get this quite often, the individual didn't look at it and they could have applied for the green card 6 months ago. Okay, so that's an important thing to know about, to be aware of. Okay.
Thank you to all of our followers. Again, you can follow us on all of our social media platforms at Beltran Brito LLP. Thank you, and stay tuned for the next one.
Thank you.